All right, everybody. Welcome to the Creative Finance Collective. I'm Andy Fowler. If you're just now joining us, this is our weekly get together to discuss all things creative finance, creative financing, subject to buying, real estate investing. So if you have questions, we're here to take your questions, and we're here as long as we get questions. And we have a couple folks here. We've got Sean St. Clair, and we have Scott Horn. Scott, I can't see you, but maybe we can hear you. Are you there?
Well, can you hear me, Andy? It's Susan.
Hi, Susan. I can hear you.
Hey, well, he's right in the courthouse in Cleburne finishing a foreclosure.
All right. Well, we'll just
And I don't
hang
know.
out.
I'm working to try to get the picture up. So hopefully I'll do that. So he'll be on in a few minutes. Oh, there he is.
All
He's
right.
ready for you. Hang tight.
You heard it live, folks. We've got a lawyer in
Okay.
court. on a
I can't get
foreclosure.
that.
The wrong location, by the way.
All right. If you're just now joining us, we're working through getting a couple lawyers on. But if you have questions, make sure to post them in the chat. As I mentioned before, we'll take questions for as long as we get them. So as long as you guys are able to interact and ask questions, we will continue taking them on.
Down on this thing.
Let's see.
Uh,
As we wait for
What in address?
a couple folks to join here, I'm going to put them in the background here. Sean, how things been going? You were saying that agreements for sale have been a hot thing recently.
Oh, I don't know. Land trusts have been kind of a hot topic more recently, especially with concerns of the due on sale and things like that.
Yeah.
And the other hot topic out there is, agreements for sale land contracts are a hot topic. Another hot topic is just ongoing regulation. We saw the South Carolina regulation. A lot of people are expecting other regulation to come down the pike. So those are kind of hot topics. But yeah, I mean,
to get your picture.
all in all, I think
it was close right here.
things are good in the sub-2 world for the most part.
Yeah. Scott, it looks like you finally got on. How you doing?
I had to ensure Susan knew how to take the little closure of the camera off.
Oh.
We're doing good. We just finished up our last foreclosure of the day.
Wow. How many you do in a given day? Is there a day set at the court for those kind of proceedings?
In Texas, it's the first Tuesday of every month. And we had, I don't know, we probably did 4 or 5 today, everywhere from San Antonio and Bexar County down to Brazoria County, Montgomery County. Here, and we're in Johnson County right now. And it's just a matter of getting things put together to handle it. So it wasn't that bad, but we probably had 12 to 15 foreclosures this month. But the good news is the great majority of those solved the problems, paid, did something. So it made it kind of nice.
That's good.
But there's a few of them that unfortunately don't work out.
Do you do a lot of foreclosure work, Scott?
For our investor client base, we do in the creative finance world. So more often than not, we're foreclosing on owner finance type transactions, which means in most cases, when the investors sell these at a premium price, there's not a lot of equity in the properties, if any at all, along the way. And so usually the lender always buys these back.
Okay. Have you seen, since you do some of that work, just kind of an economic temperature gauge, have you seen an influx in foreclosures, or is it just kind of business as usual?
No, I mean, I think we talked about this last week a little bit. We have actually seen an influx. We're not accustomed to doing, large volume of foreclosure deal. We're typically used to doing maybe 3 or 4 a month, maybe 5, and usually they all clear out with the exception of maybe one. But this month it was a much larger volume, and it's kind of like we're looking at going, is it just an anomaly, or is it a market indicator, or just what is it? Now, the fact that so many people did cure the defaults one way or the other that the lenders were willing to accept, maybe that's a good sign. And the fact that we only had to actually foreclose on, I think 3 deals today, maybe 4, if I remember, is a good sign. And you still don't like to do even 3 or 4 if you don't have to.
Sure. Well, we have a question here. So we'll go ahead and get to that. It is a creative finance related question. We've had this one over time, though I'm not sure I've seen it recently, but I'll pose it to you guys. If I buy subto, what are my options if the lender invokes the due on sale clause? So the dreaded invoking of the due on sale clause. What are the options? Are there options?
Well, I'm going to take the lead. I'm going to let Sean tell me how wrong I am on a lot of things, which I think he loves to do. What you hear so often in the marketplace, guys, from a lot of people are, well, you either have to sell the property, sell the note, if you have a saleable note format. Now, obviously, you can always transfer the property back to the original seller, who's the original borrower. But then what do you do? I think that's really the secret at that point in time, is how do you navigate it from there? And, I like to work through a trust document oftentimes. As we talked about last week, hopefully a proper trust document where the seller then puts the property into a trust, and the investor and the back end borrower navigate it appropriately. And there's some fancy footwork and paperwork to be done in order to recreate, for lack of a better word, the wraparound mortgage back into the trust. But at the same token, as you're doing this, it's, there's never going to be 110% guarantee, I don't think, unless you just pay the loan off, that it can't reoccur again. And I'm trying to get my head straight here, guys. Once you convey the property back to the seller, we want to provide that document, of course, to the lender, let them know that it happened. The next thing I do is actually I convey it into a trust of some format and make sure we get insurance handled appropriately so that the trust becomes the proper insured and things of that nature. And before we ever consider finding a way to get it back to the original borrower again, I want to let it sit and rest for a bit and give the lender or their attorney or somebody an opportunity to look at title and make sure things have been done properly. Once you let that pass, then there's some things that we can do that can help to benefit getting the buyer back into an ownership position. But typically it's going to be an ownership position through that trust. If that wasn't confusing enough.
Yeah.
Yeah,
That makes sense. And, in Texas, you guys are a little bit, it's a little bit more complicated. In Arizona, we have the ability to convey it back to the seller and then turn around and do an agreement for sale or a land contract, and with the same substantive terms as the original, wrap transaction, and nothing really changes. In fact, I'll jump ahead on the next question. I don't know why people, Go ahead.
Yeah, I'm just jealous that you guys can do that.
Yeah, we can. Now technically that's still a violation of the due on sale, uh, especially as to the Fannie Mae Freddie
yeah.
Mac loan. But knock on wood, I've not seen a land contract or agreement for sale subject to called. The deed is still, title is still showing in the name of the seller. Seller still has that, fee simple interest in the property. And so I know VA for sure takes an approach on that it's fine. And I think other lenders kind of just turn a blind eye to it, even though technically they could call it due. I honestly don't know why more buyers here in Arizona and in Wisconsin don't use either land contracts or agreement for sale. It's the same document, just different name. I don't know why they don't just buy it directly in that instrument, frankly, other than it does provide less bankruptcy protection. But other than that, everything's pretty much the same.
Well, in Texas, Sean, first off, you can't do it, obviously.
Right.
You can, but it becomes extremely problematic. And even if there's an existing mortgage, it's prohibited from doing it to a consumer. I have found historically, as someone who has done thousands of contract for deeds here in Texas back when we could do them, it was a viable tool. But if you're trying to capture, in most cases, a larger down payment, which most investors want to try to capture, and work more closely with that buyer to protect them, the buyers really want to be a deed record owner other than an equitable owner of the property. But sometimes, when push comes to shove, yes, this is the solution to the problem. And, every buyer out there is going to be a little bit different. When you're talking to them, some may readily accept the executory contract in some format, and some simply may not. But it's kind of like a lease option. With a lease option, you cannot demand the same size of the down payment that you can demand when selling a home outright and carrying back let's say a wraparound mortgage. And it's been my experience, it's the same thing with an executory contract, being a contract for deed or an agreement for sale. And so every little deal is different. I think every investor is different in what they're trying to accomplish. And sometimes you can, and sometimes you can't.
Yeah, and that's just it. I see your point, and I think it's part of it is a lack of understanding on the buyer side, and even the party, the investor who's purchased it under a land contract agreement for sale, really explaining what that means. And a lot of people, even attorneys, don't fully appreciate the fact that the buyer, the purchaser, for all intents and purposes, owns that property. The only reason the deed is staying in the seller's name is as security for performance of the purchaser under the agreement. It's like their mortgage. It's like a deed of trust or a mortgage. They're securing their interest by holding the deed. It's the same as, I always use this example. When you buy a car, if you finance it, the title is held by the lender as security for the repayment. That's exactly what an agreement for sale or land contract provides. It doesn't provide any less rights for the purchaser. The purchaser, gets insurance in their own name. The purchaser pays the property taxes. The purchaser can improve, maintain, repair. They can lease, assuming the contract provides you can. They can do everything they want with that property. It's theirs. The only difference is seller holds that title, and that's just the different way of financing the transaction as opposed to the traditional wrap. But yeah, I see your point. You're like, well, if I don't have the deed, why am I going to put down a big deposit?
One more thing I'll say, Sean, to all of that, and I think you're on point in a lot of arenas. And I know that every state's a little bit different in how they approach and handle these situations, but if a investor is looking for a back end exit strategy, specifically being the sale of the mortgage, most buyers of this product, they don't want to buy an executory contract. They want to buy a mortgage. Not always, but I do think that you're going to gain a larger purchase price if you have a mortgage versus a contract for deed, basically.
So you're talking about them selling the note.
Yeah.
So if I go and so I basically carry the paper. I have a note, and I want to sell the note to a note buyer. I'm with you 100%. No, they generally aren't going to want to buy a land contract. Not that they wouldn't, but I could see, and frankly, it could be done, but the paperwork on that would be a little bit more complicated.
So, follow up to this question about the due on sale clause. The follow up is, what should I do before I buy subto to best prepare for the risk that the lender calls the loan due? Is there some preventative measures that can be planned for or taken on the front end that helps this situation? Or is it just, hey, just be prepared for the risk. It's going to happen, and this is what there's nothing you can really do to control that on the front end, or is there?
I'm not a huge.
Go ahead, Sean.
Yeah, go ahead, Scott. No, I'll let you go first.
You know, what we try to teach investors and educate them on is, first and foremost, have good disclosures between seller and yourself. So everybody's on the same page going the transaction. Next, I try to tell them, guys, try not to touch the lender if you don't have to. Yes, you want to have power of attorneys and authorization documents for communication purposes, if and or when needed. But try to navigate the subject to deal through the online accounts, as opposed to sending out a power of attorney, picking up the phone, calling and talk to people, because every time you do that, you're possibly raising a flag that something's going on. Why are you asking for X, Y, and Z? The other thing a lot of people do is they order payoffs on these transactions, as opposed to a reinstatement if it's in a foreclosure mechanism. And I think when you order a payoff, you could possibly be raising a red flag, because is the lender now looking for a payoff? Maybe, maybe not. But it's just something that doesn't need to be effectuated in that regard. Then I think the other thing to do is make sure that loan is brought current, paid current, make sure payments are paid current, and by all means, make sure you handle the insurance properly, so that the lender doesn't have a reason to kick out the insurance and then start looking to see what the heck is going on. Now, with all those things said and done, there are sometimes situations that arise that just flat out happen, and there's no rhyme or reason as to why. But usually there's some underlying cause that caused them to start investigating. I can't say what that is, because I just don't know what it is sometimes.
Yeah, I agree. Make sure to get access to the online portals, so you can just make the payment electronically. And that way you can also see any increase in the mortgage payment due to taxes and insurance. And you're staying up to date on that. The less touches you have with the lender, the better, and you're going to mitigate your risk. As far as, on the front end, what you can do to prepare in case, say, the due on sale clause is called. One, and you mentioned this, is the disclosure with the seller. You need the seller, this shouldn't be a surprise to the seller that this happens. The seller should have been disclosed that this is a risk, and then also disclose, well, what happens if this happens? And so you have a seller, hopefully, who's like, oh, it happened. Okay, so where do we go from here? And who's cooperative with you in working through the issue. And there's, like I've put together for my clients, and a subject to, clause addendum, which lays out there what that would look like if the lender called it. Once again, I mean, if the seller doesn't cooperate, they don't cooperate. You can't really force them, even if you have a contract, but it at least helps lay out the seller. So when you come to them and say, for example, in Arizona, hey, let me deed it back to you. Let's do an agreement for sale. Remember that addendum we signed that said that that's what we were going to do? Oh yeah, okay. And you have it kind of laid out there for them so that they understand, hey, this is what the this is what this situation will look like. So it's really communication with the seller. It's making sure that the seller knows on the front end. I would try to always, follow up, make sure you know where the seller is, make sure you have good cell numbers, good emails, even addresses for the seller, so that you can, contact them if something does happen with the due on sale.
No, and Sean, just to reiterate what you just said, is what I heard was communication. Make certain that I like the sellers to meet and know the buyers, have each other's emails, phone numbers, so if things do occur, you have open lines of communication. And sometimes investors, they don't want to touch that stuff. They just want to stay away completely. It's like you have to know who your lender is. And I mean by the lender, who the seller is.
Right.
How to reach them in case these things occur. And it's okay. It's just helping them understand that you're here to help them out, take care of things, that down the road, you know what, guys, things could happen. And if they do, we're going to work together to try to solve it and take care of it the best we can. And most people like to hear that. But sometimes investors, for whatever reason, they want to shun communication, which is, I think, the wrong thing to do.
Yeah.
Good information. If you're just now joining us, this is the Creative Finance Collective. Make sure to post your questions in the chat. We're taking questions for the hour or until we stop getting questions. So it's important for you to post them there. And we've had a few questions here on the due on sale clause, what happens if it's called, so on and so forth, and how to prepare for that. Jumping to another question, a little bit different, creative finance related though. As a seller on a sub-2, can I charge the buyer an interest rate that is higher than the rate of the original loan? So the loan we're taking, it's subject to. Can I understand why they're taking that subject to, but can I charge a higher interest rate as the seller? I suppose if maybe they're carrying some equity, I don't know. I'll let you guys go.
I'll just make a quick comment here, guys, because I hear this question all the time, and I have to chuckle at it. Because very simply, when you're buying a home subject to an existing debt, you cannot change the existing loan on the property. Or if you're selling a home subject to a third party, you cannot change that except the lender and the original borrower can do it. So what is the simple solution? It's a wraparound mortgage where now you can charge that increased interest rate or term or dollar amount. And I would hope that the investor marketplace, if you play in this arena, these are the simple basics that you have to understand and learn on how to do that.
Yeah, I had a transaction I worked on, and it was brilliant. A realtor actually figured it out and brought it to me to paper, but the seller lived in a property for over 2 years, decided to turn it into a rental, turned it into a rental for like a little over 2 years, and then they decided they wanted to sell because they wanted to obtain their capital gains exemption. but they also liked the monthly cash flow on the property, and the mortgage was like, it was like a $300,000 mortgage at 2.8% or something like that. So they ended up doing it was like a $750,000 transaction. They ended up finding a buyer who could bring 250 or whatever the capital gains exemption is, brought that to the table, and they put that cash in their pocket, tax free. Then they financed like $500,000 at 6% interest, which is still lower than the market rate. And so they're basically receiving kind of almost what they would pay in or receive in rents, after you include expenses and costs and whatever, holding costs and maintenance, repair. And basically they walked away with, cash in their pocket, no capital gains, and now they're selling the property or they're financing it at, 500,000. Now there might be some capital gains on the, long-term capital or whatever on the installment payments, but nevertheless, they're getting this great cash flow, and they're getting on the $300,000 loan, they're getting the difference between the 2.8 and the 6%. So basically they're getting like 3.2 on somebody else's money, which is pretty awesome.
Now, how many of the folks you work with are actually thinking through this? Because I would have to imagine that a lot of the folks or investors that are pushing these deals are buyers, right? And they're calling to look at potential sellers that want to sell and are willing to sell it creatively by letting them carry that note and they stay on it. Do you really see that many sellers even thinking through this at that kind of strategic level?
No, remember
I will say from my perspective, I'm just going to say from my perspective, the answer is simply no.
Right.
We really don't. Our client is primarily the investor who's in the middle, who may have signed the contract somewhere, and they're just looking to earn a quick fee and a quick buck. But rarely do I ever deal with a seller who is going to ask those kind of questions.
Yeah. Well, on a few months back, somebody posted a question in here that said, what do you see as the biggest mistake that sellers make on subject to transactions? And I'm going to say it again, and all the investors are like, don't say this anymore, ever again. The biggest mistake that sellers make is they don't ask enough. They don't ask enough for their subject to transaction. They don't recognize the value of their low interest rate loan against the property, and they don't sell it for enough, money, whether that's through, a change in the interest rate, adjusting the interest rate so that they get a markup on the subject to loan, or whether or not it's, asking a larger purchase price because of the fact that the buyer can step in and, make payments on a low interest rate loan. And I think that could change at some point where, as more and more real estate professionals become aware of this, and to the extent that they are willing to adopt it, I think that, you put that in like the MLS or something, that they would allow the buyer to, acquire the property subject to the existing loan. I think that they would get, number one, tons of offers. Number two, I think they can ask a premium for that property.
Yeah. So we got a follow-up question to that. And I think you kind of answered it, but how can a seller market this opportunity to buyers? We know how the buyers are tracking down sellers. They're cold calling, they're doing a lot of different methods to try to find folks that might be interested in this. But, a seller watching this are thinking, wow, this sounds interesting. This is intriguing. I want to take advantage of this. What's the best way for them to get in front of, buyers that want to do this kind of thing? Is it get a realtor and get access to the MLS?
Yeah, I mean that or Craigslist or Amazon, or not Amazon, Zillow, or wherever you list for sale by owner.
Yeah.
Scott, what
No,
were
and
you gonna say?
yeah, and I agree with you, Sean, that you got to get it out there. But first and foremost, a seller has to have a modicum of knowledge of what they're doing and they're requesting. You asked earlier, what is some of the seller's biggest mistakes? And what I see is, if I ever represent a seller selling to an investor or someone else, I probably would not do a subject to transaction, but I'm going to do a wraparound. Just because
Yes.
I like to see a new note entity, a document executed between seller and buyer. And you can modify the terms a little bit as needed. But also, in that same scenario, I see these sellers, they never ask for financial information from a buyer. Ever. They don't ask for guarantees. Nothing. They just sell it out and move on. And rarely do they actually know who's buying their home besides some entity.
Right.
Now, if a seller does have that modicum of knowledge, if they go find a realtor, the question is will that realtor actually understand what they're trying to do and accomplish? Because so often they don't. And so here in Texas, we do try to educate realtors about this type of a business, how they can help sellers and buyers both, and give them the tools they need and the things that they should be asking along the way to work with the sellers and the buyers out there. But if the seller just wants to try to do it on their own, they can, but they have to know, if I do get an interested buyer, how am I going to contact? And title companies, they don't look at the disclosures like here in Texas, other states where you don't have those issues. And just because you think you're closing in a title company doesn't mean that. I think they need information before they really. I'm on, but I'm not seeing any.
Oh, well, Scott, I think you're having, or you're going through a
We're back
part where.
on again.
Oh, okay,
Yep.
there. Can you hear us okay?
I got you. Can you hear me?
Yeah, I can hear you. You just had some cell service problems.
Yep.
But
Imagine
it
that.
is an
We've only
interesting
driven 25 miles.
Yeah. Well, it is an interesting discussion for sellers because there's a lot of opportunity out there for the seller that wants or to consider different options. It is interesting that you bring up kind of the due diligence that people or sellers fail to do on other people. I wonder if it's a question of psychology. Nobody likes it when the bank does all of their due diligence into you and all the paperwork you have to sign. So maybe the thought is, well, I don't want to have to do that to somebody else. But it is amazing that somebody would go into those kind of terms with another party without really knowing who they are. Well, guys, that's all the questions we have so far. If you're watching and you have a question, you can go ahead and post it here in the next minute or so. Otherwise, we're going to cut it short. Anything you guys wanted to add while we're here?
No, I think I'm good on my end, unless we have any more questions.
I'm afraid. Can you hear me, guys?
Now we can hear you. Yeah, you're cutting out a little bit. Well, folks,
No.
that's all. Go ahead,
All right.
Scott. Go ahead.
I'm just going to say that, whether it's the investor marketplace or whether it is the seller marketplace, getting decent knowledge, not just trying to take a quick course, listen to a few things, but getting your hand around it, become a student of the industry, and sellers won't ever do that. And dealing with a seller direct who is trying to do this on their own, I think things are going to become a major issue out there because so few people really understand this industry properly. And that's where you really hope oftentimes that the investor world kicks in because they do so much better than the seller on their own. And realtors, unfortunately, right now aren't the answer.
Yeah. Good information. Well, everybody, that's all the questions that we have. So we're going to go ahead and put the show to bed, so to speak, and make sure to join us next week, every Tuesday at 2:00 p.m. We're taking questions. So if you've got them and you want to talk about creative finance, we're here to talk about it. Scott, Sean, thanks so much for taking the time. I know you're tired, Scott, from foreclosing all over the state of Texas. So we want you to get your rest, and we'll see you next week.
All right, we'll see you guys. Bye.
Guys, thank you.